Okay, so we're starting our next presentation. I don't know if someone can hear me outside of the hall, probably not. But anyway, as I said before, we're continuing our talk, our conversations on IP. And for this, we will have two amazing people who have traveled here. Alessandra Capriglia and, and Elio de Tullio. And they have come here and are representing China IP Help Desk and the Tullio and Partners Intellectual Property Attorneys. And they will talk about intellectual property protection in China and Southeast Asia for the games industry. A round of applause.
Yes, it works. Well, it's great to be here, finally in an on-site event. And we're here today to talk about intellectual property protection in China, Southeast Asia. So yes, it is a very smooth transition from the other session. I will briefly introduce the two European projects that sponsored the presence of our amazing IP expert, Elio de Tullio, and then I will give him the floor to run the training. So first and foremost, the China and Southeast Asia IP SME help desks are two European-funded projects that were initiated by the European Commission in a way to respond this lack of understanding of intellectual property matters in third countries, especially in those countries where the legal system is even more complicated, full of jargon, and culturally maybe also a little bit distant. So the goal is to assist these companies to have a better understanding of the legal system in those countries, and to guide them to develop an IP strategy and to help them on spot in case of disputes and infringement. I am Alessandra Capriglia. I am a project executive for the China SME Help Desk. Here is my email address. Feel free to drop me an email to connect, and I will be happy to connect you with our IP business advisor for any question related to IP in China, and of course also Southeast Asia. I can connect you with my colleagues from the other help desk. So in a nutshell, what we do is we provide free of charge first-line advice to European SMEs. Why SMEs? We feel that SMEs have limited resources to tackle those issues and to really spend resources on, let's say, law fees and so on, just to have some questions answered. And also, SMEs tend to maybe underestimate the impact of the exposure of their solutions and products in third countries without having protected their assets beforehand. So we do help European SMEs that are already in China, Southeast Asia, or are planning to go to those countries. And we help them with IP protection, intellectual property protection, management, and enforcement. Of course, I want to make clear, we offer advisory services, all free of charge, but we do not replace a law firm. We help you to develop your intellectual property strategy in those countries, but if you need to register your rights, if you need concrete help in dealing with disputes, then you have to find a lawyer. So our most important service is our helpline service. You can see here our helpline email addresses where you can send all your inquiries, and our IP business advisors will reply to you within 3 working days, of course in a very confidential way. We also organize with business support organizations, trainings and workshops and webinars. Well, especially during COVID times, it has been webinars, so we're happy to go back to on-site trainings on specific intellectual property rights and also sector focus. For example, we organized recently a workshop together with the EU SME Center on biopharma and so on. We have a website that is full of very interesting material, and we do have an IP guide on gaming industry. Unfortunately, I don't have printed version here, but please do get in touch with me. People who are following us online, you can drop me an email and I can send you this IP guide where you can find all the basic information about intellectual property protection for game developers. And we also have regional fact sheets, for example, that provides you with key information about, for example, cost of IP registration and all these general matters. Yes, here are a couple of examples of what we offer on our website. The China and Southeast Asia IP SME help desks are part of this big family of international IP help desks. So there are similar projects providing the same services, covering also Latin America, India, the European region itself, and very soon also Africa. Feel free to visit our website where we are all connected under the umbrella of the European Commission. And yes, follow us on social media to be updated with our training activities and with our publications. And yes, and we do publish our webinars on YouTube. I'm sure you can find something about game industry. And now I'm very happy to give the floor to Elio, and do make sure to ask him a lot of questions. It's a great opportunity to ask questions directly to this awesome lawyer. So Elio, the floor is yours, and enjoy. Thanks a lot.
Yes, but okay, we can do both. So, thank you for this nice invitation for the first edition of Game Wave Festival. It's great to be here after 18 months of video conferences and webinars. And so my name is Elio de Tullio. I've been working for the IPR SME Help Desk China and Southeast Asia since 2013. It's a great team, part of them based in Brussels, and then the other part in destination countries, China and Southeast Asia. My name is Elio de Tullio. I'm lawyer, IP attorney. I'm the founder and managing partner of the Tullio & Partners, that is an IP law firm based in Rome, with liaison offices in other parts of Italy and also in New York. I used to work with all sectors, so compared to Tommy and Annette, they are game specialists, we are IP specialists, so we cover all the sector, but we are an IP boutique. And this previous presentation was the perfect, let's say, complementary session in order to talk about and speak about IP. We have a lot of activities towards China and Southeast Asia, but basically intellectual property is international. Protections start from the country of origin. That is why it's highly advisable to have an IP consultant, IP attorney in the country of origin. So where you have the head of, let's say, the center of operation, the center of the starting of creativity and innovation. So for indie game producers, it's better to have, you know, their IP consultants very close to them, let's say, even for confidentiality matter. Let's talk about China and Southeast Asia and why game industry is so important for this country. Well, the game industry is a big driver for China and Southeast Asia. Between 2018 and 2017, there was an increase in revenue in the Chinese game industry from 18 billion RMB to 200 billion RMB. Now let's say the amount of the market can be considered something like 50 billion US dollars. So according to the last market research. And one of the factors driving the growth of the game industry in China and Southeast Asia was the development of internet infrastructure, and of course the COVID emergence, and together with the 5G technology rising in 2020. And another factor was the rising popularity of esports. For instance, Free Fire was the most downloaded game in 2019, and the leading esports professional players in China are listed here. You can see that they have a lot of numbers that can justify this growing market. So, IPR and video games. First of all, before going into details about IPR and video games, I would like to follow up some of the questions and complement Tommy's answers. First of all, NDA. Let's say that in China and Southeast Asia, NDAs can be essential, but sometimes it would be better also to sign, let's say, an NDA plus, that is an updated version of NDA. It's called NNN, non-confidential, no-news, so non-disclosure, no-news, non-circumvention. So it's a document according to which you list all your intellectual property rights. So provided that you have filed and registered your IP rights, we will follow this matter in a few seconds. And so in this case, you will oblige your counterparty also to avoid to use and to circumvent the agreement, to circumvent the rationale of the agreement. So let's say the validity of this NNN, so non-disclosure, non-use, non-circumvention, have been validated by Chinese courts, for instance, and some Southeast Asian courts that recognize the, let's say, the validity of the agreements, and they, of course, provided that they have been signed in Chinese, they provide the Chinese language as applicable language and law, and they considered as competent court the Chinese court. So let's say that they should be, let's say, assessed and drafted in order to be accepted by Chinese courts. Another answer to previous question is related to how to pay lawyers. Let's say that it's always a problem, but there are a lot of initiatives, above all at European Commission level. So in European Union, there are a lot of initiatives launched by European Commission in order to support SMEs to have, let's say, a preliminary first-line advice for free from IP consultants. In EUIPO, EUIPO is European Union Intellectual Property Office, that is the competent authority for trademarks and design. You have a pro bono service with a list of IP firms to which you can file an application and from which you can receive a free advice. Of course, you have all the free advice already mentioned by Alessandra from China, Southeast Asia, Latin America, India, and very soon Africa IPR SME help desk. And for instance, you can also apply for an IP pre-diagnosis. That is another service launched by European Commission aimed to support the preliminary needs of SMEs in terms of carrying out the state-of-the-art. Indeed, the state-of-the-art is essential. If we talk about IPR in video games, you can have a lot of intellectual property rights, and let's say that these are just an example, because the approach is always a case-by-case approach. I always say to all the lawyers, engineers of my firm that you need to have a white paper on your in front of you and forget any competence, any previous case, because your let's say approach should be fresh. Indeed, creativity is always useful for lawyers as well, not only for video gamers and for producers. So you need to apply the existing rights. They are always the same since a long time. Copyrights, trade secrets, trademarks, patents, design, to new situations. So with copyright, you can protect the music, the code, the source code, the story, characters, art, box design, website design, but also trade secrets are important. trade secrets is everything can be considered with an economic value, but should be kept secret, and you have to apply all technical, legal, and physical measures in order to keep it secrets, in order to challenge them before a court. So customer mailing list, pricing information, publisher contacts, middleware contacts, developer contracts, in-house development tools, or deal terms. You can protect also the name of the game, okay? Tommy already mentioned this. The name is very important, and the trademark and patents are the most powerful IP rights, very, let's say, easy to enforce before a court. So company name, company logo, game title, game subtitle, but also characters, name of the characters of a game can be protected through trademarks. And finally, let's say, it's not so common in video games, but it's very, very strong right, patents. So hardware technical solution, but also softwares, if they provide a technical effect. So they have, let's say, the inventive step, inventive gameplay or game design elements, technical innovations such as software, networking, and database design. These can be protected through patents. They are considered inventions. So this is the relation between IPR and video game. When starting thinking about IPR? Yesterday, because today is too late. So it is the first thing you have to consider before any kind of launching of business, because everything that is disclosed cannot be, let's say, get back. So let's say that the first step is always an analysis of the state of the art, searches, analysis of database, and receiving a preliminary, let's say, opinion about, you know, the creativity, the novelty of your idea, and of course the legal requirements. There are a lot of free database. There is a Spassen for patents, TMView for trademarks, Patent Scope even for patents. Unfortunately, there are no database for copyrights, because copyright filing is only a way to reverse the burden of proof. So in order to, let's say, claim the paternity and the certain date, the certain date of your invention, if somebody is saying on the contrary. So let's say that for patents, trademark, and designs, you can carry out a search. Of course, the best practice is to receive an opinion from an IP consultant that assess the novelty and inventive step, creativity, originality, and, for instance, individual character for design or distinctive character for a trademark. So the state of the art is the first step. Let's say that how to obtain a copyright protection in China and Southeast Asian countries. Usually, the copyright arises in not depending from a specific filing of an application. The publication of a creative content can be considered the starting date of your protection. But once again, in order to reverse the burden of proof, if somebody says the different, you need to file an application. And it's better to file an application in the country in which you like to operate. So in case you are operating in the European Union, you can file an application in single member states copyright offices. If you like to operate in China, we'll see you can file an application at the Copyright Center of China. Or in Southeast Asian countries, in all the offices you will find listed in my next slides. So it is always, for European SMEs, it is always a good suggestion to file an application and register your copyrights, even if the protection should arise, not depending on any formality. You can also, you should consider also the strategy before launching your project, because you can select different strategies. For instance, you can protect single elements of your video game, you can protect the video game as a whole, or you can protect both. You can select both the protection. The legal basis, if we talk about China, you will find the references in this slide, but if we talk about the Southeast Asian countries, it's really fragmented. Let's say that they are all members of international conventions, so the Berne Convention that allow applicants to receive protection in any country of the world according indeed to the Berne Convention. The Paris Convention, that it is the convention related to priority rights. I will tell you now in a few minutes what is priority right. And the TRIPS Convention. Be aware that Myanmar, for instance, is a very particular country, so if you have any clue to go to Myanmar, consider that they are out from the main international convention in the world regarding IP. When I talk about Paris Convention, I refer to the right, the faculty that the Paris Convention allows applicants to obtain protection from the date of the first filing in the country of origin and have a priority right for a certain period of time. So, for instance, if you file an application for a trademark today, that is 24 September 2021, in Latvia, you file a trademark application, you have 6 months in order to extend the protection of your trademark application worldwide, claiming the date of the first filing. In case of patents, you have 1 year of priority. So you can file an application, for instance, in China before March 2022, claiming and starting the protection from September 24, that is the date of the first filing in the country of origin. So video games are complex works of authorship and are copyrightable together with their elements. So the copyrightable elements are, of course, software, if not protected through patents, characters, skills, personalities, scenes and props, themes and sounds as musical works, plot design, interpretation, activity schemes as literal works, source code, game rules, website design as computer program or as look and feel, and continuous pictures in running the game as cinematographic work. But you can also think about patents and trademarks, once again. Example protection of patents include new useful processes, so gameplay methods, graphic techniques, user interface communications, or machines like computer programmed with computer software, or new ornamental design, because according to some jurisdictions, for instance, the Chinese jurisdiction, but also the US jurisdiction, designs are, let's say, design patents. In European Union, design are a specific peculiar right, industrial design, lasting 5 years, renewable for 5 times for a total of 25 years. And finally, last but not least, trademarks. You must name your video game, your business, but also your character through a trademark. And the trademark will be very, very useful in case you would like to start a legal action. Legal action are quite, let's say, complicated, sometimes very costly, but think that if you manage to build up a blockhouse around your project, notwithstanding you don't have a specific right to file and register, that blockhouse can be used in terms of unfair competition against your counterparties. Indeed, in China, the majority, in China and Southeast Asia, the majority of case law, the majority of dispute regarding IP and IP-related issues are unfair competition litigation or copyright litigation. Even for trademark, you have an international convention that is the Madrid system, the Madrid Protocol, where you can find 123 countries, so you can file an application and extend the protection in 6 months, claiming the date of the first filing in these 123 countries. IPR in China. I will skip some of these slides because we are running out of time. Don't forget that, don't forget that in China you have a first to file system, so the first who filed the application is the owner of the right. That is why I was saying that the protection should start yesterday, because never ever try to export and promote your business in China and Southeast Asian countries without a protection of your trademark, your business name, the name of the characters of your video game, because that would be very, very complicated if somebody is going to copy you. In terms of cost, probably you think that this kind of protection are very expensive. They are not. Probably the most expensive part is the analysis, the preliminary analysis, so the state of the art. That is facultative, so it's not compulsory. You can also skip this step. Of course, my suggestion is to file genuine rights, so where you have assessed the novelty and the other legal requirements. But if you don't have money, please file an application claiming China and Southeast Asian countries. In any case, before disclosing the name of your business, the name of your project to third parties, because this could be really the first step to bear in mind. In terms of duration of protection, trademarks can last 10 years, renewable forever, so it will be your treasure for all the rest of your life. Patent can last 20 years from the first filing, and design and utility models, according to a recent reform of Chinese legislation, can last 10 years with the payment, of course, of annual fees, because there are some fees in order to maintain the right in the course of time. This is just an information. In China, the government tried to, let's say, simplify the procedure of IP. First of all, there was a change of name. So before 2018, there were different authorities for different rights. Now we have only one authority for patents, trademarks, designs, geographical indication. That is the China National Intellectual Property Administration, CNIPA. But for copyrights, you still have another authority, that is the Copyright Protection Center of China, authorized by the National Copyright Administration of China. So in case you would like to file an application for a copyright in China, you need to refer to that authority. China is very active in terms of international conventions. So it is a member of all the convention of intellectual property, Madrid System for Trademark, Patent Cooperation Treaty for Patents, Paris Convention, so the Convention on Priority Rights. Think that the Paris Convention was signed in 1883. So we are talking about two centuries ago, when all the states considered intellectual property important for a good relationship between countries. And this is the explanation of priority mentioned before. So the owner of an application for registration of an IP rights filed in one of the member states of the Paris Convention may use a priority period of 6 months for design and trademarks and 1 year for patents and utility model from the filing of the application in the country of origin to extend the protection of the first filing in China or Southeast Asian country to a national filing in that country. So this is very good, because with the first filing you can guarantee the protection worldwide, and that is why it's not a matter of expensive activities or not. It's a matter of allocation of resources. So thinking before going, and if you allocate the resources in the right way, you can spend hundreds of euros to ensure the potential protection worldwide of the name of your video game or other issue. I will. Okay, here there are some details about protection of trademarks in China. The government tried to speed up the procedure and also to allow the possibility to protect non-conventional trademarks. For instance, trademarks composed by sounds, holograms, or for instance, three-dimensional packaging or other kind of unconventional products. But let's say that the legislation in practice is always changing from time to time. So the best practice is to check with your IP consultant before carrying out the searches and before carrying out the first filing, what is the state of the art at that moment. For instance, classification. China is a member of the NICE classification for trademark. And if you like to protect your trademark in China, you need to select some international classes. For instance, I try to select the classes for video games, 9 computer game software, 41 game services provided online from a computer network, or 42 computer software design. But China applies a specific sub-classification that you should consider before filing. Or patents. You can protect patents at the international level using the PCT, the Patent Cooperation Treaty. And in this case, you can extend the protection of your patent in 153 countries. That is almost all over the world. You have different types of patents, invention patents, utility models that are small patents, and design patents in China. But this is not so important for game industry, even if the look and feel and let's say the design in terms of aesthetic part of your product should be protected through design patents. Let's go a little bit into details about copyright in China. I will also skip some of these slides because we are talking about what to do in order to file an application at the Copyright Office of China, the Copyright Protection Center of China. Once again, even if the protection should be automatic, voluntary registration provides clear proof of ownership of the right that is useful in the event of a future dispute. So in this case, it is strongly recommended to protect your video games, all that is, let's say, the aesthetic part of the video games, but also the software if it doesn't have inventive step through a copyright application. And I will leave you this information about copyright legislation because there are all the steps you have to carry out in order to protect your copyright in China. The duration of the protection is 50 years after the death of the last of the authors that contributed to your opera, your creative video game. In some cases, you can also decide to go to a public notary in order to have the date of your first, let's say, creation of your work certified by a public notary. Of course, my suggestion is to go for an application to the Copyright Center of China, but in case you can also opt for this solution. The public notary can be also useful to collect evidences in case somebody is copying your video game, is copying the look and feel of your website, is copying something that belongs to you. So it is highly advisable to have the evidence that in a certain date you discover this infringement, and somebody with a public authority's certification, like a public notary, was there in order to you know, certify the date of the discovery. Now some case studies, the most important and the interesting part. Let's say that the cloning video games, or let's say being inspired by video games, it's a general practice, it's a common practice. As somebody, and from the industry, it is also considered, in some cases, acceptable. Because there are different, let's say, legal possibility to frame this kind of possible infringements. So you have, for instance, the one-for-one code copying that is generally considered not acceptable, but in some cases of reverse engineering, it was considered acceptable if it could fall under the fair use doctrine. Or, for instance, there is the imitation of game mechanics or remixture of multiple game mechanics that is considered generally acceptable, let's say. But if we go to game reskinning, that is the general practice, and it is also the general practice in China, here it's a gray area. So you can find decisions against and pros. So game reskinning, which involves changing the graphics of an existing game while retaining original expression and actual gameplay. So let's see some case studies on cases of reskinning. This is Nexon Holdings versus Tencent. So let's say in this gray area of reskinning, the Chinese courts try to find some principles of game copyright protection on one side and game copyright infringement on the other side. The first criterion that was used in this case, Tencent is a big company, as well as Nexon, is the criterion of access. So the plaintiff, in this case Nexon, shall prove whether the defendant was able to access their work. This is a way to prove the bad faith. So if there was the possibility to access the work, this is the first pillar in order to show the responsibility. The second criterion is the criterion of substantial similarity. So the plaintiff shall prove whether there were substantial similarities between the alleged infringed game and the infringing game of the defendant. And the third one is the degree of originality of each element of the game required to obtain copyright protection, because not all the elements can obtain copyright protection if there is the minimum level of originality required by the law. Let's go and see how it ended. So in 2007, the South Korean game giant Nexon Holdings filed a complaint for copyright infringement and unfair competition against Tencent Limited in China. Nexon argued that Tencent launched its online strategy game Kukutang and that it was a copy of Nexon's popular game Pop Tag, and argued on the basis of the ground was that there were 37 similarities between the two games. Because of course you need to go into details and say, first of all, if the counterparty had access to your work, and the second, if there are, what is the degree of similarity. That is why I was meaning before that always a case-by-case approach is needed. Tencent argued that there was not substantial similarity between the two games and that the plaintiff could not prove his proposition. And then the court's findings were the following. On the burden of proof, although Tencent could have accessed the plaintiff's work, which was released 1 year before, the court held the plaintiff did not prove that the 37 similarities appeared prior to the defendant's game release. So even in this side of the level of similarity, there was, let's say, a breach in the production of evidences. On the alleged similarities, 9 of the 37 alleged similarities were within the login interface of game, which is classified in China as general expression, so let's say publicly available. So the plaintiff shall not be entitled to the exclusive copyright. You cannot claim copyright on anything if there is the minimum level of creativity for which copyright can be sought. On the similarities regarding the game props, they could not reach the originality requirements of copyright law, so the court deemed that they should not be protected by copyright law. Moreover, from an artwork perspective, there was a difference in the design of the game props in the plaintiff's and defendant's game. So the conclusion of the court was that the defendant game Kukutang and the plaintiff's game Pop Tag were not substantively similar. And this is another case in China, quite interesting. Taji Panda versus Hua Kiangu. Taiichi Panda is an action role-playing game developed and operated by Suzu Snail Digital Technology Co. Limited. The plaintiff, Taiichi Panda, claimed that another mobile game, Hua Kiangu, copied either numerical settings, game rules, and user interface, and that Hua Kiangu only changed the, sorry for the pronunciation, Alessandra, only changed the appearance of the characters in the game, which constitutes reskinning. So the defendant, in this case, Hua Kiangu, argued that the gameplay, the structure of the game, the functional layout of the interface, and the game value ratio are all within the scope of an idea, and so, once again, let's say, generally known and not copyrightable. And the video game as a whole does not constitute a work in the sense of copyright law in China. This was the approach of the court in this specific case. And but then the findings of the courts were different. So they considered the game Taiichi Panda constituted work created by a process analogous to a film, like a cinematographic work, and it should be regarded as a whole. So the court maintained that all the functional elements are not copyrightable as such, so all the abstract expression, non-original expression, industrial, the standard expression, etc., other components, but nevertheless, detailed presentation of game rules via the game interface design constituted a specific expression of gameplay. So at the end, the court ruled that the defendant infringed the plaintiff's copyright and give reason to the plaintiff. So these are, even if these cases date back some years ago, they can be considered a way on how Chinese court assess infringement of copyrights in the specific sector of video games. If we go to Southeast Asia, let's say these are information that we have already seen previously. Once again, copyright protection arises automatically as soon as a work is created, but it is highly advisable to file an application at the Copyright Office in each single country you are going to export or, let's say, distribute your products. Once again, the protection should start in the country of origin. In terms of duration, you have quite fragmented duration of 5 years, not so much because the only country in which the duration is 70 years is Singapore, but the voluntary registration is available in the majority of countries except Brunei, Myanmar, and Singapore. Even in Southeast Asia, you need to file an application because this will allow you to enforce your right more easily before the court. So you need to have the proof and reverse the burden of proof of the starting date of the protection of your copyright. In this case, enforcement is easier, but sometimes in these Southeast Asian countries, the best enforcement is, let's say, try to have good cards in your hands, but then start a mediation with the counterparty. So it's better to start a litigation, but then find an amicable settlement. In terms of copyright registration procedures, you can find here some information. You will find them in the presentation. I will not go into details, but you will see that the copyright protection can start with a reasonable amount of time in terms of official fees. We are talking about 10 euros, 30 euros, something like that. So what you can add is the, let's say, the professional consultancy. So at the end of the day, you can have, you can secure your project with hundreds of euros, but on the other side, you are starting probably a project that can value thousands of euros. So it's really the first pillar you should try to secure. In terms of licensing, before in the previous presentation, it was mentioned the chain of rights. Let's say the sequel of rights. So licensing is one of the examples of sequel of rights. Be aware that in some countries like China and Southeast Asia, you need to request the authorization of public authorities in order to approve the content of the game and to issue an individual license. In this case, in China, you need to receive, if you like to engage an online publishing service, you need to obtain a permit, an OPS, from the Administrative Publishing Controlling Department approval. So in this case, game developers intending to launch a game in China have to license games with a qualified and licensed domestic Chinese game operator. So at the end of the day, you need to have a partner in China and Southeast Asia in order to develop the business there. The same in Vietnam or in Singapore. In Vietnam, you need to have a contract of business cooperation or a joint venture with a Vietnamese partner. In Singapore, distributors of video games are required to declare the game titles to IMDA through the IMDA online service. Of course, I try to summarize some of this information because for Southeast Asian countries, there are something like 10 countries you need to check before starting the business there, and case by case if something has changed. I will skip this part on trademarks. The only slide I would like to show you that's very interesting is this one, because you have local peculiarities for non-conventional trademarks in each Southeast Asian country. So for instance, you can file an application for a trademark constituted by a word, a name, a signature, but also a color, a sound, a scent, holograms, positioning, and motions, sequel of motions. So these are considered unconventional trademark. The roar of the lion of Metro-Goldwyn-Mayer is a very well-known sound trademark, but you have a lot of jingle of computer programs that are also trademarks. And these are a way to make your video game distinguished for the public and, let's say, push the others to find something else in order to avoid to be considered an infringer. You have a lot of peculiarities of the trademark system in each Southeast Asian country. So I will suggest you to check on the website of Southeast Asia IPR SME Help Desk in order to see if you are doing well and to double check the work of your IP consultant. The duration of the trademark is always 10 years. I will not go so long on this. And remember that a first-to-file system is always valid in these countries. So the first-to-file application is the owner of the right. So don't promote your video game on the internet or a beta test or other thing before filing. Before having filed your application in these countries. Even for patents, you have a quite fragmented duration of patents. You have, once again, invention patents that are the traditional big patents, let's say big invention, sometimes also related to computer programs, if they have the sufficient inventive step. Then you have small patents like utility models, and then you have design patent, the protection of the aesthetic part, the look and feel of your website or your video game. You can use also these rights in interdependent way. So that is why a prior study, a prior assessment of the best protection solution is the best way to proceed. And finally, we go and we present the unfair competition. Remember that at the very beginning I said, if you have all these pillars in the right position, trademarks, patents, design, utility model, trade secrets, then you have a blockhouse that can be used in unfair competition cases. And unfair competition, if somebody is doing something wrong, not only, let's say, the infringement of the IP right, but also it is infringing the fair competition rules. So in this case, defendants can be found responsible for unfair competition practices when they copy game elements protected by relevant IP law. Game elements cannot be sufficiently protected under the relevant intellectual property laws. That is why we fall down in the unfair competition law. And the defendants acted in bad faith or are found to make false or misleading publicity about their game or try to take advantage on the fame of plaintiffs' games, brands, images, and acts that can confuse the public. So let's see another case study. This is about the video game Fantasy Westward Journey 2 against Huadu Information Technology Limited, started from NetEase Inc. The former is a holding company that provides online game portal services, among others, YY, one of China's largest social media and entertainment platform. In this case, NetEase claimed Huaduo abusive conduct of using NetEase's copyright game content for broadcast online on its platform YY without its authorization. NetEase's main allegation was that Huaduo had infringed NetEase's copyrights by organizing and allowing users to use unlicensed game content of Fantasy Westward broadcast on YY's platform. It also alleged that it is illegal under the anti-unfair competition law in China. With regards to the copyright issues, the legal queries were whether the animated pictures of Fantasy Westward can be considered as copyrighted works, and if broadcasting of copyright-protected content for obvious commercial purposes can be considered as proper use. So the Guangdong High Court confirmed the decision of the Court of First Instance that animated pictures of Fantasy Westward should be considered as a copyrightable as they are a series of music accompanied or non-music accompanied pictures whose process and the final expression, audio and video, demonstrate a high level originality and creativity. Held that live broadcasting does not fall into the categories of rights covered by copyright protection and fall under the fair use doctrine. Nevertheless, in the case of a stake, the Huaduo's live streaming shall not be deemed as a fair use due to the images volume which exceeded the proper use. And at the end, the court held that Huaduo's conduct had infringed upon the normal licensing right NetEase possessed on the game pictures involved in the case. But on the other side, Huaduo started and sued NetEase. This in the framework of a normal, let's say, strategic approach to litigation. Huaduo filed an antitrust case against NetEase at the Guangzhou Intellectual Property Court as a strategic response. And Huaduo alleged NetEase abused its dominance by forcing players to stream its game Fantasy Westward on its own platform and by bundling the installation of the game and the platform. So what were the findings of the court in this case? The Guangzhou Intellectual Property Court stated that abuse of dominance should be based on the potential abuse of the company market dominant position. And given that NetEase has no dominant position in this case, bundling Fantasy Westward and NetEase CC software is in line with traditional industry practice. So at the end of the day, the position of the Ts was considered not as an abuse of dominant position. So thank you for your attention. We are on time for some questions. Just to summarize some takeaway messages: start protection before launching your project. Use pro bono services of the European Commission, of the China and the Southeast Asia IPR SME help desk for preliminary first line advice, and of course sign a 999 or an NDA before starting negotiation with your partners in China and Southeast Asia. Thank you.
All right, thank you so much. And if anyone here has any questions to either Elio or Alessandra, you can ask them now. Int?
Yes, I have one question. I have a question for my information. What time does it take to get through all these courts? It was 1 year, 2 years, 3 years for the company?
Well, I don't know the duration of these specific cases. Usually, Chinese courts are not so slow, but usually you don't receive probably the right, let's say, the right answer in the first instance. So sometimes you have to appeal the decision, because higher court can go a little bit more in depth on some specific question, and this was the case in the litigation we have presented. They are not slower than European courts.
Right, any additional questions? So I actually have a question for Alessandra, and the question is quite simple. What is an SME?
An SME is a small medium enterprise, so it's not a big corporate. It's a company that has not many offices around the world, but is starting to internationalize. We consider SMEs also startups, small teams. So those companies that have a little bit limited resources in comparison to those big corporates.
Thank you. All right, any additional questions? If not, then thank you so much, both of you, for coming here. And right, this is Elio. Thank you so much. And this one is Alessandra. Thank you. Okay, round of applause again.